Hi, my name's Stacy Morier, and I'm the founding lawyer of Estate Connection Law Office in St. Albert, Alberta. Lately, we've had clients coming in, and they're a little bit sheepish to tell us that they haven't had contact with their children for several years, and in some cases, decades. I'm not passing any judgment. I know that families are very complicated, and there's a variety of situations that lead to estrangement. It may be that your child moved to the other side of the world and just doesn't have time to travel back. It could be that they married someone and became an integral part of their spouse's family. And so maybe they're not having time to have contact or have moved on in their lives. Or it could be some other matter. And I've heard a lot of different stories. I'm here to tell you that this is nothing to be embarrassed of, and we see it at least once a day. There's really three options that you have when you're estranged from a child. You can write them out of your will entirely and not provide them any bequest or gift. However, if they're disabled or are a minor, that's not an option. You can include them in your will and give them a gift, either large or small, or you can do a combination of those two. And in our office, we've seen all three done. For some families, they want to write their child out of their will, especially if you haven't seen them in decades. And the concern is what will happen when you're gone. Well, if you're going to be writing a child or a loved one out of your will, you should make sure that there is a specific acknowledgement in the will that you've done this and the reason you've done it. So, for instance, you may say, I'm leaving my son nothing in my will because I haven't seen him for 10 years and we're estranged. I love him, but because of time, we've moved on, and that's why he's not left anything in my will. It's very important you include some sort of acknowledgement so that your other family members, your son, and the court, if people litigate, know why you've done what you've done. A second arrangement that you may look at putting in your will is giving a gift to a charity and acknowledging that it's been gifted in your child's name. This provides two options. It acknowledges the relationship you had with your child, it provides you with a tax deduction, and there's no argument that your other children were enriched by leaving your child out of your will. Alternatively, you may want to give your child a smaller gift. So, for instance, you may say, I'm going to give $5,000 to my son that I haven't seen in several years. And I do this because we're estranged. And if my executor can't find him within 2 years, I want this gift to lapse. There's a variety of ways that we can deal with estrangement in wills. But what I don't want this to stop you from doing planning and getting the essential documents in place. It's a concern, but it's a concern we can conquer. Contact Estate Connection Law Office. We're here to help.